Hello, my name's Rob Trickler. I'm the owner of All County Evictions in the law office of Rob Trickler. One of the most frequently asked questions of my office is how much time is this procedure going to take and what can they expect as far as the steps involved. I'm going to walk you through some of those and help you understand what to expect as you go through this eviction process. It all begins with a notice. Now, your notices are different. 3-day notice for pay or vacate. You've got 5-day notice to pay or vacate if you're in a mobile home park situation or if you're using an MLS document. 10-day notice to pay non-rent related charges or some behavior modification compliance issue. 20-day notice to terminate the tenancy. Now, the 20-day notice is 20 days and ending at the end of your rental period. It's not 20 calendar days. So if your rent runs from the first of the month to the end of the month, you've got to give the 20 days and it must end at the last day of the month. If it's mid-month to mid-month, then it has to end mid-month. Now, one additional day needs to be added if you end up posting and mailing as opposed to personal service. That's required by statute. Now, to help you count, I would also point out that you're not counting the day that you give them your notice. Day one would be the following day. Give them through the last day, and then the day after that you can start with a summons and complaint. That begins your lawsuit. Now, summons and complaint by statute requires that you give them at least 7 days for them to answer. We call it a response date. Anything less than that, and it's deficient, you give them 7 days, typically plus 2 or 3 for your server to make some attempts to get them served. Now, if you get them served, your lawsuit has begun. If not, if you get 4, 5, 6 attempts and you're not getting them served, maybe they're evading or maybe you just can't find them, then a possibility would be to go get an alternative service order. Now, at that point you have to file it. Typically we start these without filing, and I'll explain why in a minute. But you would file it, you'd obtain an order allowing alternative service, which means you could post and mail the summons and complaint. In that event, you're going to have to add at least 3 days for the mailing. That's required by court rules. So your minimum of 7-day response date actually becomes 10 days to respond. Now, assuming you get it served, let's say before you filed it, you've got a possibility to stipulate. Stipulation is essentially it's a written agreement, it's a settlement that would allow you to not have to settle. Now this is possible, or excuse me, not file. This is possible even if you have already filed it. However, you've got more leverage if you haven't filed it. But the stipulation would summarize in writing the agreement that your tenant and you have reached, and it would be binding so that if your tenant actually defaults on that agreement at some point in the future, you could then take it in to the court and get a default judgment. However, if your tenant follows through on everything that the agreement obligates him to do, then you end up finishing this lawsuit without ever having to file it and without ever paying the filing fees, assuming you didn't have to go alternative service to get that far. Now, you can't come to an agreement and you don't work out a stipulation, then there's a couple of ways the lawsuit can go. Depends on whether or not your tenant ignores the lawsuit or whether they answer and respond to the lawsuit. If they ignore it, once that response date has run, you can take a default. You file the action for $85 if you haven't already done that to obtain an alternative service order. At that point, that same day, we'll take it to the sheriff, and the sheriff will be given their writ of restitution ordering the return of your property to you. At that point, it's up to the sheriff's schedule. Now, one of the time limits, though, is they may not execute the writ for 3 full court days after the writ's granted. So let's say you go in on Monday and you're granted a default judgment, given a writ of restitution, Tuesday would be the first day, Wednesday the second, Thursday the third. Friday would be the first legal day that the sheriff would be allowed to execute that eviction. That's a minimum. Above that, you're on the sheriff's timeline. The sheriff will contact us and tell us when they've scheduled the eviction, and we'll pass that information on to you. And that varies, so it's harder to predict how long that step's going to take. Now, if your tenant answers, then what we need to do generally is set it for a hearing. If we're not going to end up with a stipulated agreement prior to a hearing, then setting a hearing is at least 10 days out. You have to provide 10 days to account for the minimum time plus the mailing time that the statute requires. Presumably the hearing will resolve the issue, at least of possession, in which case you're back to taking the writ of restitution to the sheriff the same day and back on that same timeline where the sheriff has to hold on to the writ for a minimum of 3 full court days. After that, you're on the sheriff's schedule again. Well, that is the basic procedure. Those are the general timelines. And hopefully this will help answer some of the questions that you have before starting your eviction. We'd be happy to help. Give us a call. If these don't answer your questions, bring your questions to us. We'll take care of you. Thank you.